In this video, we're going to discuss whether you should file a patent owner's preliminary response. If one of your patents is challenged in an IPR, the first thing you should do is hire experienced PTAB counsel. After that, you next need to decide whether to file a preliminary response. The preliminary response is due 3 months after the PTAB sets a filing date for the petition. In the first 2 years of IPR filings, patent owners filed preliminary responses about 80% of the time. In the most recent fiscal year, that number increased to 86%. And based on those statistics, it's clear that patent owners most of the time are deciding they should file a preliminary response. So what are the pros and cons of filing one? Your best chance of defeating the IPR is at the institution stage. The same 3 judges who decide institution also make the final decision. So once they decide to institute, you have to convince them that they are wrong. And this counsels in favor of filing a preliminary response to try to win at the institution stage. Previously, a patent owner could not include any expert testimony with a patent owner's preliminary response. But with the rule changes that became effective on May 2nd, 2016, the patent owner can now include an expert declaration with the preliminary response, making it easier to rebut any complex technical arguments. But any factual dispute created by such testimonial evidence that's material to the institution decision will be resolved in favor of the petitioner solely for purposes of determining whether to institute a trial. In other words, if the judges find that the expert declarations create a factual dispute, they will err on the side of institution to allow the record to be more fully created in the trial. Now, it may be difficult for a patent owner to avoid a factual dispute when filing an expert declaration with a preliminary response. One strategy to avoid that problem is to try to address issues that were not addressed in the petitioner's expert declaration. Because the petitioner ordinarily does not get to respond to the patent owner's preliminary response, this could avoid the PTAB finding a factual dispute. Alternatively, to try to avoid a factual dispute, you can only address issues of law and avoid any factual issues. But it remains to be seen what the PTAB will view as a factual dispute in this situation. Now, let's look at some of the cons. You give your opponent a preview of your arguments 6 months earlier than they otherwise would get them if you file a preliminary response. And some people view that as a reason not to file one. In addition, the patent owner can speed up the process by waiving its right to file a preliminary response, which happens about 15% of the time. So if you decide you're going to file a preliminary response, what types of arguments should you include? First of all, you should retain an expert immediately. An expert can help by reviewing the petition, the prior art, and the petitioner's expert declaration. And of course, if you decide to file an expert declaration with your preliminary response, your expert can help you with that. There are 2 types of arguments you could include: procedural and substantive. Some examples of procedural arguments include estoppel, real party in interest, whether the references qualify as prior art, and whether the petitioner is subject to the 1-year bar under Section 315B. If you have any of these arguments available, you should definitely include them in a preliminary response. Now you need to decide whether to include any substantive arguments. Even though the new rules allow the patent owner to include an expert declaration with the preliminary response, the patent owner still needs to decide if it makes sense to do so. Now, some examples of substantive arguments you could include are failure of motivation to combine arguments in an obviousness situation, claim construction, inherency, and also whether the references are missing one or more of the claim limitations. In sum, a decision whether to file a preliminary response must be made on a case-by-case basis depending on several factors. The May 2016 rule changes tip the scale a bit towards patent owners by allowing them for the first time to submit expert testimony with a preliminary response. But the patent owner still has to avoid creating any factual disputes in this situation. For more information about patent owner preliminary responses or about IPRs in general, please visit our blog at ptablitigationblog.com.